Hi, everybody. Excuse me. I just want to, before I go very much further, my organization is a HHS and Office of Violence Against Women DOJ-funded organization in the Bay Area, and we do technical assistance, training, research, and policy work on issues related to domestic and sexual violence and human trafficking in the Asian and Pacific Islander and immigrant communities, with the mission of trying to advance protections and increase access to services for underserved communities. And right now, most of my work these days, I've done lots of work on access to the court systems, welfare, labor protections, and all sorts of things. But these days, the work is dominated by rapid changes in immigration policy that are happening almost on a daily basis from the administration. And so when I was asked to do this presentation, I was told I had an hour and 15 minutes. And so what I'm going to try to do is just give you very, very short snippets. I won't be able to go into a lot of detail about a lot of these cases because there's a lot happening both at the federal level and in response, the state has done quite a few things as well in terms of trying to make sure that non-citizens in the state continue to have access to the legal system and to services. And so what I'm going to do is try to talk a little bit about the federal system, some of the changes at the federal level, and then talk specifically about some of the things that Washington we've done in the state that may impact your practice. I understand there's a wide range of different agencies here, and some of you will see more of the impact with respect to the state changes in your practice than some of the others. But I've been doing training all over the country on some of the federal changes, and many of those topics would be a full 2-day CLE, and so that is not going to happen. But I am going to talk about some of the changes the administration has done since January of last year that have particular impact on the willingness and the ability of immigrant communities to be willing to engage in the systems that you have and that you work in. With respect to some of the executive orders and some of the guidance that's coming out of Department of Homeland Security and Department of Justice. I'm going to talk a little bit about what the actual policy that is supposed to be guiding Immigration and Customs Enforcement, or ICE, at the courthouse and enforcement at quote-unquote sensitive locations and what those are. I'm going to talk about the newly released public charge. Hasn't been published to the public Federal Register yet, but there was a draft proposal that was released last week, and we have been told that it will be published this week or next to the Federal Register, and so we'll see if it is the same as what was leaked. And then I'm going to talk about some of the things that have been happening at the state level. The Supreme Court passed an evidence rule that just went into effect last month, as well as House Bill 1022, which may impact some of your agencies if you have to make any findings related to certain criminal activity, and then the governor's executive order as it relates to state agencies on immigration inquiries and collaboration with immigration enforcement. And so, let's see here, how do I start? I'm going to talk first about many of the immigration executive actions. I'm not going to go into detail as to what they are, but when this administration went into office, I will say, we were watching to see what would happen in terms of how the administration chooses to interpret existing immigration statutes and policy. And I will say it has been rapid fire in terms of changes of long-standing policy that we've been working on. We've worked with for, some of these policies for decades. And I have been doing immigration-related work since the mid-90s. I will say a lot of these changes are really radical in terms of how current statute is, or statutes are being interpreted. But bigger than just this, specific regulatory interpretation of the statutes and case law, or modifications to case law, I think that what's bigger and more impactful for immigrant communities in our state is the amount of publicity and rhetoric that is being circulated and rumor around a lot of these policies, and those the information about policies and how they are interpreting law are often blown in a way that is much more impactful than the actual interpretation of statute and law. And so we are really seeing a lot of fear in communities and people being unwilling to access longstanding systems, including access, people trying to get immigration status are much more fearful. I mean, they may have a legal process to be able to follow, and folks are much more concerned about even trying to follow that. And so, that's just the larger framework. But starting in January of last year, I'm not going to go through what all of these things mean, but we started with the travel and refugee ban in February that has, of 2017, that has been modified several times, which directed an overhaul or close review of the refugee program and refugee admissions into our country, as well as impacted or created or specified a specific travel ban or prohibition for immigration and both non-immigrant temporary visas, as well as permanent long-term visas for individuals from 7 countries, and so we are seeing I'm sure you all read about the litigation challenging these proposals in court, and with respect to the refugee ban, or the travel ban, that has been upheld, and so people are from many of these countries, Syria, Venezuela, North Korea, and not that we had a lot of immigration from North Korea, but are impacted and barred from entering unless they can get a specific waiver, and so that is in effect now, and so we are definitely struggling with trying to help people reunite with family members, etc. So there was that. I'm going to spend some time talking about this next one, the Interior Enforcement Executive Order, and what it means for increased ICE activity in our communities and interpretation of various policies. There was also the Border Enforcement Executive Order. The agency was directed, Border Patrol and Customs Enforcement were directed to increase detention of folks at that within 100 miles of the border. So some of you may be seeing more activity and less flexibility from Border Patrol if people are detained. This was the executive order that spoke to building the border wall, increasing the number of Border Patrol agents, and that's more, we'll see more of that along the southern border, but certainly along the northern border as well. Increase in the number of Border Patrol agents was included in that executive order, and right now the big question is whether or not Congress will choose to fund any of these initiatives that the agency or the administration put forward. Certainly much closer inspection of non-immigrant visa programs, and we see the impact of that in our state with respect primarily with H-1B or temporary worker visas. Our universities, our software companies bring many temporary workers to come and work for a specific amount of time and people can come for a specific purpose and work for the sponsoring entity that sponsored them. And so we are seeing just a big shift in how those cases are processed. There's a huge demand, especially from our tech industry in the state, for temporary workers and So we are really starting to see just a lack of certainty on how those cases are being processed. And it's not that they've stopped processing, but really just in terms of, as all of you know, having some certainty in how a process works helps, you be able to assure clients, et cetera, about, what's going to happen in their case, how they, giving them some ability to make plans about whether they're going to purchase a home or, stay, raise children, et cetera. And so there's just a lot of uncertainty happening in some of those non-immigrant visa programs. This one's a big one. The next one, end of the Deferred Action Childhood Arrivals Program, and just that ended what's popularly known as the Daca Program, which was a program for young people that came as children without permission into the United States, and they had to have shown that they had lived here continuously for a certain amount of time, and they were generally of good moral character, that they had a certain level of education or were pursuing education. And so a lot of those individuals had an administrative status that let the administration know, I'm here and I'm not causing problems in the community, and it gave them permission to work. And so a lot of there's about 700, almost 800,000 people across the country that have accessed that program, and there are many more people that might be eligible but haven't. And right now, this executive order is stayed, and so people are continuing to renew their work authorizations and continuing to go to school and all of those things. But depending on what happens with the litigation in that case, those people that have that status may all of a sudden be without it. And some may choose to not stay in the United States, and some may choose to stay and go back into having, being completely undocumented and in the shadows. There's also been termination of temporary protected status for various countries. In our state, we see a lot of folks from El Salvador in particular, but temporary protected status is also another administrative status that the Department of State does a declaration that says, XYZ country, there's a lot of uncertainty or turmoil happening there. And they do a designation for certain countries where the administration chooses to not, force people to go back to their country if there's a lot of there in some situations there's been, natural disasters like hurricanes or earthquakes, or there's been cases where there's been, some kind of endemic disease or civil war, those kinds of things. And so with respect to El Salvador, and I just mentioned that because we have a larger El Salvadoran community in the state it started off with, I believe it was an earthquake, and then there's, just a lot of uncertainty and turmoil with respect to violence and, lack of infrastructure in that country, and almost 150,000 people are impacted by the termination of that program. And what's happened with all of these programs is the administration has said, we're going to end that program in a year. You have a year to basically figure out another way to get immigration status, or you need to go back. And so we'll see what happens with a lot of these folks. I mean, there's probably 500,000 people among all the various countries, Haiti, various African countries, et cetera, Honduras. So we'll be seeing what happens with folks from those countries as well. And then this last week, last Saturday, the administration published a draft public charge regulation that talks about the interpretation of the public charge statute, which is in our immigration code, that public charge is a ground of inadmissibility, meaning that if you are likely to become a public charge, you are ineligible to enter, whether as for a temporary reason or for to get a green card. And so there's been a pretty significant expansion in that, and I'll talk about that a little bit more pretty significant expansion of how that regulation is going to be, or that statute is going to be interpreted. And so for those of you who in particular are with Department of Health or Department of Social and Health Services, this may be an area where there's a lot of concern and question, or even with ESD or L&I, there may be some questions about the impact of this particular guidance that's just come out. So, as I said earlier, I'm going to spend a little bit of time on the Interior Enforcement Executive Order. One of the things that that executive order did was change, state what is, a change in enforcement priorities for the administration on who they are going to go after in terms of pursuing removal cases. And the notion of, this is what the order did was terminate all guidance that had been in existence, some of which went back for 3-4 different administrations that spoke about prosecutorial discretion. And what that means, prosecutorial discretion in the context of immigration enforcement is, the administration knows there are, 11, 12, 20 million undocumented individuals in this country, and they had set up priorities, or there were guidance about whether or not, how the administration was going to use its resources to pursue removal proceedings. And just like, your local prosecutor will decide they're going to put a lot of resources into, pursuing perhaps a domestic violence charge versus, spending their resources on marijuana possession or whatever. I mean, it's that same concept in the context of immigration. So what the administration did was, in addition to some of the statutory grounds that are, listed as grounds of deportability or removability, such as criminal grounds or security-related or fraud or other priorities for the administration to pursue removal proceedings, they also added on the right this list of new priorities, and so including those that have pending criminal cases, whether they're, somebody's actually pled or been found guilty, doesn't seem to matter anymore. Anybody convicted or charged with a criminal offense, and that definition of criminal offense is widely expanded, and so the cases that you're hearing about at the border of people being charged with criminal entry, that had never been for decades, never been a huge priority for the administration. And in terms of charging folks, first of all, charging folks for entry without inspection, but then in addition to that, actively pursuing removal cases in those situations. And this next one is one that we are probably in many of the cases that you're hearing in the news when somebody's married to a U.S. citizen or has a whole bunch of connections to a community, and it's usually those that have a prior order of removal where we're hearing about cases where, this person's been married to this person, they've lived here 30 years, they have, 5 kids, and they have a restaurant in the community. I mean, those are the ones that are getting all the publicity, is probably somebody that may have been ordered deported many years ago. They may or may not know about that, but now they are a priority for removal, and so this is what we're hearing about. And these are the cases also with folks that they may have a path to be able to apply for residency, and so they're applying and they're going to their immigration interview, and they're arrested at their immigration removal, at their interview and put into removal proceedings. It may be that they have a really old order of removal. These were the cases also in the last administration where folks, they may have had that old order of removal, but now they have young U.S. citizen children, or they're the primary caretaker in their family, and the prior administration, had actually guidance in terms of prosecutorial discretion to say we're not going to actually try to remove parents of U.S. citizens and permanent resident kids or whatever, and so now that guidance around prosecutorial discretion is gone, and these individuals are now high priority for removal. And some of these other ones, those have committed fraud in applications before a government agency. So your findings in some of these cases might have a huge, pretty big impact on whether somebody is a priority for removal. Those who've abused a program related to receipt of a public benefit, that is not interpreted, there's no interpretation of that, but in terms of the findings that you make in some of your cases, that may or may not, meet the priority, make somebody a priority for removal. And those believed to pose a threat to public safety or national security. And I was at the statewide judges conference last week and was talking with them about what they are starting to hear and see at the courthouses in terms of where ICE is picking folks up at the courthouse or being lingering outside the courthouse or specifically aiming going through their records to see if somebody might be at a court hearing. What we are seeing is, in terms of just the stats for your information, last fiscal year, 2017, there was over 100, I think it was 111% increase over fiscal year 2016 of people being deported for non-criminal related reasons. And so we are definitely seeing a lot more of those cases where, somebody, they don't have any criminal charges, they don't have any convictions, et cetera, and they are ending up in deportation proceedings and for various reasons. And what it's really brought out is a lot more fear in communities of accessing any kind of state-related services or benefits. And so I'm not going to go into the specifics of all of these memos. They are actually in your materials on the discs, or however you receive them. But these are the official policies from Immigration and Customs Enforcement on, where and when they'll be, what process they're supposed to follow in order to do enforcement at the courthouse. I will say that after some very highly publicized incidents at courthouses across the country, Justice Fairhurst from our Supreme Court, asked, along with justices from California, New Jersey, and other states, wrote to ICE various letters. There were several letters asking for some clarification and to ask that courthouses be designated as sensitive locations. And sensitive locations, there's longstanding guidance, and the administration has said our sensitive locations guidance is still in effect. But sensitive locations generally are they've designated as funerals or churches or schools, hospitals, and other places. And so, and the administration responded and said, no, we're not going to designate courthouses as sensitive locations. And so they did issue a policy that designates, how they'll be doing enforcement at courthouses. And so it speaks to, they will not, the policy only applies to civil immigration enforcement, not if ICE is doing, for example, some kind of criminal investigation to drug trafficking or human trafficking. I mean, they have a different division that does criminal investigations. So this policy only speaks to whether they're going to pursue somebody who might, have a prior removal order, or, they're going to put them into deportation proceedings. And just a flag for you all, deportation and removal of individuals is a civil procedure that has pretty big life consequences, but it is a civil process. And so the policy is specific to civil immigration enforcement, and they are states that when practicable, ICE officers will conduct actions discreetly. And so now we're starting to see stories in the news about people, ICE officers in plain clothes and videos. So they're trying to not wear their uniforms to scare everybody away from the courthouse. And they are supposed to be specific targeted actions so that they're looking for a particular individual that, by name that they have identified in court records perhaps and are, searching for somebody. So their enforcement actions at the courthouse are not supposed to be, just everybody that is, looks like they might be from a foreign country. We're just gonna, stop and inquire about everybody's immigration status at the courthouse. And so they are supposed to get supervisory approval in order to do it, in terms of getting an okay from the field office director. And they generally will not be doing enforcement action at the courthouse in courtrooms that are specifically about issues that are not criminal cases. So they're not supposed to be going into, your protection order docket or your small claims court or family court. But I know many of our courthouses around the state are just one building that have, everything's together. So, that may or may not be helpful in this context. And they generally, ideally should be trying to engage in enforcement in non-public areas so that the, first of all, so they're not scaring everybody off. And it also makes, just the last point on here, is makes a reference to specific guidance relating to enforcement against victims and witnesses. There is guidance, and there's a copy of it in your materials, relating to victims and witnesses. That is the one prosecutorial discretion guidance that we've been told remains in effect, that victims and witnesses are not a priority for enforcement. And if somebody is a victim or witness and they are put into removal proceedings, their own policy states that they have to, do an assertion that they didn't get information from the perpetrator of domestic violence or sexual assault, et cetera, that says that they didn't, provide a leak to ICE to direct them to come pick this person up at the courthouse. So, there is reference in terms of courthouse enforcement policy there. And we are, hearing about cases around the country where it seems pretty obvious that they fail to follow their own policy. And one of the challenges, I think, that they, to be fair to the administration or for the line staff, is that they have conflicting directives, and the question is, are they aware of whether existing statutory directive is still in place, and how are they supposed to follow that when they're being told by up above that they need to do this other thing. And so that's one of the challenges that all of us in the field are trying to help immigrant communities with, is they have conflicting direction, and I can tell you what their policy says and what the statute says, and they're given conflicting directive, and so I'm not going to be able to guarantee that you won't be detained at the courthouse if you go get a protection order. So the question is just, how do you help people, advise people on what to do in that instance? And so, let's see here, sensitive locations, just a little bit more information about that, and it continues in effect. I guess schools, daycares, colleges, universities, bus stops, medical facilities, these are designated in their policies as sensitive locations. And I think, at least with respect to churches, I think that's the one place that we haven't seen Border Patrol or ICE actually going against that policy, but we've certainly been hearing about cases where they are doing enforcement at bus stops and in hospitals and other things. And so with respect to churches, there are some very highly publicized cases where people are just deciding to stay in churches when they know that they have been ordered removed and are trying to avoid removal. So let's see here. The other thing is the sensitive locations memo applies to ICE. It doesn't apply to Border Patrol. And so Border Patrol, for those of you along the within 100 miles of the border, which is a pretty big part of Washington, Border Patrol has a lot more leeway to go into sensitive locations in all other places. And so actually the cases that we're hearing more about where there is immigration enforcement happening at the hospital, Most of those are being done by Border Patrol as opposed to ICE. And so that's just a snippet of the Interior Enforcement memo, but I wanted to give you, I work in a victim services organization, and we are certainly hearing, and this is, you can translate this across to other groups of individuals in immigrant communities for those, that may have, for example, work injuries, workplace injuries, et cetera, or might have unemployment claims, et cetera. What we are hearing, we did a survey with many of my national partners of victim services programs around the country last year, just to see what folks, because we were being inundated with calls for, requests for assistance or technical assistance about what do we tell people. And so what we heard back from over 700 advocates from across the country was that folks were starting to hear much more about they hadn't ever really had as many immigration questions before, and now over 40. What is the number up there? I can't see that. So people were responding. Yes, we have victims telling us, 62% saying victims telling us now they have a lot of immigration questions where they never really had them before. 78% of the advocates reported they were hearing from survivors. Some of them might have had this concern before, but expressed concerns about contacting the police to address victimization. 3 out of 4 of them reported that they had concerns about going to court. 43% of them reported that folks that already had civil or criminal cases pending, they were choosing to not pursue them. So either, not move forward in a criminal case or dropping protection orders. And if you want to see, the data from the survey, it's at that website right there. But, I think this also is having implications. Well, that must be the... Yes. Everybody's getting a text. All right, so I'm going to move on to just, some information about the news that was leaked last week about public charge. As I stated before, public charge is a statutory ground of inadmissibility for people seeking admission into the United States. And that could be somebody who's coming as a visitor. Somebody who's just deciding to come for a day from Vancouver. It's not likely they're going to go through a robust examination in that context. But somebody who's, they're going to be applying it to non-immigrants in a way that they never have before. So the guidance speaks to that. But it also is for people that are seeking permanent status in the United States, who are being sponsored by family members or by employers. And in terms of long-term immigration or indefinite immigration, getting your green card in this country, about 2/3 of the people that get permanent residence come through a family member. They're sponsored by a family member. And probably about 10% come through employment, and another 10% come through humanitarian protections like refugees, asylees, and protections under the Violence Against Women Act, etc. But before I go very much further, so that people are clear, the public charge ground of inadmissibility does not apply to refugees. So they are not subject to this particular ground. Neither are folks that apply for asylum, people who get status through special immigrant juvenile status. So those of you that work with DSHS that may see kids who are going through juvenile court that have have a finding of dependency, that it would be in their best interest to not be returned to their country, and they're abused or neglected, and there's an immigration status for them. That is not subject to the public charge ground, nor are folks that get status as crime victims or as under the Violence Against Women Act, protections under the Violence Against Women. So there's a whole category of folks, if they're immigrating through some of these humanitarian grounds, they're not subject to public charge. But most of the immigration to our country is, I mean, most of the folks coming in, whether for short term or for long term, are subject to the public charge ground. And so, I mean, according to some of the statistical data out there, about 240,000 people in this state would be impacted. And so I will say, you know, the proposal has not been published to the Federal Register yet, but the administration did post an advance copy to their website. And so we're going to assume that it isn't significantly altered from that advance copy. And I think that the biggest issues of concern are that the shift has really been, in this rule, talks about really looking at the likelihood of the immigrant, the incoming immigrant, as to whether they can show that they're not likely to become a public charge by their own, by looking at their health, their income, their past use of public benefits, their age, their family size, these kinds of things. There's just a lot more focus on the incoming immigrant versus in the past it has been they looked at the overall situation where they looked at the sponsors, whether, the family they were, who was sponsoring them, looked at their income, their resources, those kinds of things. And so there's a big shift really to focus just on that incoming immigrant. That's one significant philosophical shift in the proposal that's been released as well. And the next one really is looking at the history of use of benefits. Current policy right now says that they should only be looking at receipt of cash benefits, so TANF, SSI, et cetera, and long-term care. And so that's current policy, and that's been the policy since 1999, after the big welfare reform legislation passed and the regulations were issued for that. And so, they are shifting to increasing the amount of number of types of benefits that an individual may have used in the past, and including not only cash and long-term care, but also looking at SNAP or food assistance, federal food assistance, not state level. It's very clear, or the reg speaks to federal benefits. SNAP, subsidized housing benefits such as Section 8, or rental assistance. Again, it speaks to federal benefits. And this one is the most confusing, I think, for folks, is non-emergency Medicaid or Medicare Part B subsidies. And so there's, because states use Medicaid in so many different ways, in terms of funding different programs, there's a lot of uncertainty as to, how that will be sorted out. And so what the proposed regulation does is look at how the volume or the quantity of benefits used within the past 3 years. They look at, whether an individual's used benefits for more than, I can't remember what the threshold was, but a certain number of months within for benefits like that you can measure, like cash or SNAP. They look at the value of it and look at the last 3 years and see if it makes up more than 15% of the person's ability, their financial resources. It also speaks to looking at whether somebody's used some of these I guess what the word is if you can't put a monetary value to it, like Medicaid, if they've used it for a certain period of time over those last 3 years. And so the question is, it's really not a straightforward analysis, and so being able to tell somebody whether they might be impacted by this rule or not impacted by this rule will mean looking at the value of all their benefits that they've used over the last several years. It's not limited just to cash or long-term care, and so there's a whole range of benefits. And I will tell you, as a former immigration lawyer, I also worked at legal services, so I actually understand some of these programs, but most of those immigration lawyers out there have no idea what these benefits even are. And so to be able to figure out, like, how do we calculate what the value was and how that interplays with the public charge rule really has gotten to this point, made so the safest thing to do is just get off of benefits or don't use them. And that is of concern for those of us interested in the health and safety of our communities when people are not willing or not wanting to get, for example, health care or benefits that may prevent wider spread of disease in our communities or reduce trauma for children, et cetera. And so, we are waiting for the rule to be published, and there's a large organized effort from communities and local governments and state governments too. And I imagine this state will be one of the states that submits comments as to the impacts on residents of the state. And so, yeah, it's we'll wait and see what happens. But the top message I think that folks are trying to get out in the community is that receipt of benefits before the effective date of the final rule. So this is going to be a proposed rule, and then there will be the comment period, and then they'll issue a final rule. Receipt of any of these benefits prior to the final publication of the final rule, as it's drafted now, do not apply. And so we are encouraging, folks are encouraging communities to, people to continue to receive their benefits and stay on their benefits and not give them up. But we also know that people are already, fearful of receiving some of these benefits. And the other thing I want to flag on this rule is it does specify that state-only, state-funded benefits, medical, anything except cash. So state-funded food, state-funded medical, state-funded housing benefits would not be considered or not be counted. And so that is like this little thing at the very end of the proposal that talks about state-funded benefits only. And so we will see what states choose to do in terms of trying to make sure that there continues to be access to some of these types of programs. So I'm going to move on from, on that note, move on to some of the things that have happened at our state legislature and in our state courts. And this was the subject of a lot of discussion from our judges last week at their judicial conference. I want to flag for you, I'm not going to go into all of the specifics, but generally the rule, there's a new evidence rule that talks about immigration status not being admissible in state court proceedings. And so, there are some exceptions. If an attorney or a party wants to use immigration status, they have to go through an in-camera process or a motion in a criminal case as to the, whether there's bias being shown or what the relevance is of the immigration status. In a civil case, there needs to be in-camera review. And so the rule spells out the process that people need to follow. And so, with respect to civil cases, I know the rules of evidence don't technically apply in your cases, but I imagine that it may come up in some instances, and so to the extent that your decisions are being reviewed, this is the process that they are supposed to be following. And I will say, as part of the community that worked in terms of advancing the rule, the framework of the rule is intended to follow some of the existing rules or statutes relating to sexual history. So our rape shield statute speaks about, not wanting to bring in certain evidence about, this is relevant to what we're hearing about in the news these days, sexual history into, court proceedings because of the prejudice that it may cause or create. And so the model of, you know, all the case law, all the processes that exist with respect to interpreting our rape shield statute are, you know, that was the model that was intended to be the process to be followed in with respect to ER 413. And so with respect to civil cases, the rule speaks to bringing, you know, post-trial motions or having in-camera review in terms of looking at how immigration status might, you know, impact future lost earnings or et cetera. And so again, it's going to be in camera. The idea is the information shouldn't be available for public review. And so to the extent that this is raised in, I'm not sure how it may be raised in some of your cases, but if it is, that knowing that if your decision is reviewed, that hopefully that, you know, there's some process to seal or make it so that information is not publicly accessible. So I know that there was a lot of debate with the Superior Court judges on this particular rule, and I think that debate will continue for a long time. But you know, we're all waiting to see how it will be interpreted. I do know that Justice Stevens from the Supreme Court indicated that the Supreme Court just granted cert in a case interpreting the criminal aspect of this process in terms of whether or not immigration, you know, an immigration application should be admitted in a criminal case. And so that case is, I don't have the citation, but the name of the party was Romero Ochoa. It was a case out of Pierce County, and so that's on their docket for the next session. I also wanted to let you know about House Bill 1022. That is a state law that passed this last legislative session, and I don't know, you know, some of you may be impacted by this, and particularly DSHS or maybe Labor and Industries. But it's called the Safety and Access for Immigrant Victims Act, and the session law is at that link. And you should, again, have a copy of these materials so you don't have to write that down. Went into effect in June. And I'm not going to read all of this to you, but basically, I don't know, how many of you have heard of a U visa? Do anybody know what a U visa is, a crime victim visa? Under federal law, there is a form of immigration status that allows victims of certain criminal activity to apply for immigration status, and they have to show that they've been helpful in the investigation or prosecution of certain criminal activity. And so, you know, this may, in the context of L&I, for example, if somebody's been sexually harassed or sexually assaulted at work, or in the context of DSHS, you know, if you've got an abused child, neglected child, or maybe you've got a child sexual assault victim. If they're, you know, a parent or an individual who's been helpful in the investigation or prosecution of criminal activity, even though most of your agencies aren't involved in criminal investigations, if you, you know, are taking testimony or hearing testimony, that, you know, the sum of it provides information that may be the basis for an investigation. You have the capacity, you know, you make a finding, yes, I find that this child was sexually abused or this person was sexually assaulted at work, or if those are, you know, there's some type, if that person is presenting that evidence and you find that information was helpful, you have the authority under federal statute to provide a certification that says, yes, this person was helpful in the detection or investigation, prosecution of criminal activity. And so, so what our state law did was state that if you are, you know, in this context, if a certifying official, which is a, you know, possible designated official at a state agency or a local law enforcement agency or prosecutorial agency, if a victim or their family member comes and requests that this designated official do a certification for them. What the statute does is provide a 90-day time frame in which to respond to that request for certification. And so if you make a determination that that person provided information that helped detect certain criminal activity, you under the statute would be obligated to respond. And so I don't know what OAH, if there is a central, process in which the your office is looking at having a designated set of folks do this, or if it's something that needs to be done through the AG's office. But what the statute did do was provide for a steering committee to look at how do we implement this law. AG's office is a party to that, is participating in that work group, and we'll make sure that how OAH and ALJs may be implicated in the implementation of this particular statute. And so again, what the framework of the bill is really like, certifying officials have to respond within 90 days if they found that somebody provided helpful information. They can decide not to certify, but that's only if they make an affirmative determination that the person did not provide helpful information. The head of each certifying agency has to designate a supervisory official or person to respond to these requests. And let's see here. The other thing is the bill also, like I said, created the work group, etc. And so the Office of CJTC, the Criminal Justice Training Commission, will be developing some model training on this topic for state agencies and for law enforcement and prosecutors specifically for training. But I'm not gonna, let's see here. I will say, any investigative agency that has responsibility for investigation, prosecution of a qualifying crime or criminal activity can provide a certification. And these are the federal crimes, or not the federal crimes, but the crimes that are designated in the federal statute that would count. And so abusive sexual contact, incest, felonious assault, fraud in foreign labor contracting, rape, witness tampering. So to the extent that cases that involve any of these activities may end up in front of you, it's possible you may end up with requests for certification. Before I go on, I don't know if anybody has questions, because I know that different state agencies have said, well, we don't do criminal investigation, we don't do anything related to crimes, but like the federal statute is broad, and the state statute interpreting what the obligations of different entities is also pretty broad in terms of who's encompassed. And so we will be working on implementation and trying to sort out direction for various state agencies on how this will be implemented. And I guess the last thing I was going to talk about was just, I imagine many of you have already heard about this or have seen it, but there's the governor's executive order on immigration enforcement. Let's see, so this came out last year, and I know there was a lot of news about this last year because there were apparent violations of it, of the executive order that happened last fall and last spring. But the governor issued an executive order, and there's a copy of it also in your materials that talks about Washington being a welcoming jurisdiction, that state agencies continue to provide assistance and services to Washingtonians regardless of citizenship or legal status, and barring immigration related discrimination, and that state agency services and benefits can't be conditioned on immigration status unless it's already designated through some kind of other federal or state law. And so trying to send the message that our state agencies and and the things that we do, whether licensing, access to worker protections, those kinds of things are available for all Washingtonians. And so there was, direction about maintaining people's privacy and data collection that is, clarifying and restating that our privacy policies continue to exist for all the data that we collect from individuals, and specifically that immigration status or place of birth information shall not be collected unless it's required, for, under some other law or contract, for example, with the federal government, et cetera. And state agencies may not inquire into request specific documents to determine somebody's immigration status, to determine whether they're here lawfully or not. And so again, there's the exception of, in order to determine whether somebody's eligibility for federal benefits, some of those programs, yes, you're still going to need to do that. But no state agency resources may be used for targeting, apprehending individuals, for violating civil immigration laws, and specifically talks about our state law enforcement agencies not enforcing civil immigration laws and not entering into any government contracts or agreements with the feds relating to enforcing civil immigration law. And so, as many of you know, there were some stories that ended up in the news relating to particular state agency employees sharing information with immigration enforcement because immigration officers, sent a request that said they were doing a criminal investigation, and without more documentation, apparently this has been long-standing. People have been doing it forever, and of course, when you get a request from a law enforcement agency, whether it be state or federal, agencies have generally wanted to be helpful and want to stop crime, and so. There, has been a long process through which the governor's office has been, they've, had appointed a staff person, and general counsel in the governor's office has been looking at any new requests that have been coming through Immigration and Customs Enforcement to determine whether the federal agency is following its guidance around getting a federal warrant. And so at this point, state agencies are, if you get a request, your agency gets a request before compliance. I understand that the governor's office is actually reviewing all of those on a case-by-case basis, but the framework that they are using is whether or not there's a court-issued order requiring sharing of certain information. And so that, I know that governor's office went through, many of the larger agencies to look at all of your information sharing agreements with the federal government, is looking at what kind of data is being collected, whether all that data needs to be collected, whether it's, how it's being shared, for what purpose it's being shared, and they're examining, the various internal processes and procedures that each state agency is using in terms of sharing information. And I imagine that this will continue to be an exercise, but I come from a victim advocacy background, and my philosophy has always been, at least for victims who are fleeing across state lines and trying to remain safe, a lot of our databases that collect all sorts of information, have many ways that information can be shared. Not intentional, well, it's, for legitimate purposes. And so the question is, really, who has access to those databases, what information is included, and whether, people who are impacted are actually have an idea where their information is going and who has access to it. And so I think there's going to continues to be a lot more effort to look at least, with respect to immigration status, but it probably applies across a lot of different issues as to, who has access to that information. Is it disclosable some way? Is that, are our state statutes sufficiently protective of our private information, our personal information, identifying information, et cetera. And you know, I imagine there will be some conflicts between our public disclosure laws as well as our you know, contracts with federal agencies and all sorts of other, you know, factors when it relates to the information that the state, you know, our agencies collect. But just being aware that this is an ongoing task that the governor's office is working on, and I don't know if OAH has been impacted or not, but I know the agencies that you are working with have been looking at that. And so that was a quick summary of some of the things that are floating in the immigration world. I mean, there is a lot more detail and aspects of all of these policies and procedures as we move forward. And I just tried to do like a really quick skim of some of the big ones that would have some intersections with state administrative agencies. But I just wanted to share too, for those who are interested in learning more about some of these things, these are some of the national resources relating to, you know, if you're interested in immigration policies and all the things that are coming fast and furious on a daily basis, and what's the latest change, and what's the, you know, some of us are high, what's the word, you know, want a lot of input around that. There's some great resources. And then in Washington state, you know, these are some of the specific Washington resources. And so I intentionally tried to zoom through so that you could ask questions if you had them. Oh, and this last one too, I forgot to mention it earlier. The AG's office did go through and do, if you weren't aware of it, a manual on ways that communities can be welcoming communities and protect non-citizens in their communities in terms of access to services and resources. And so that's the quick run through, and I'm open to try to answer your questions if you have any.
I have a question. So some of these enforcement actions do have the right to a hearing before immigration judges who are federal judges, federal immigration judges. I've heard that they have a backlog.
Yeah.
So how does that backlog affect the administration's enforcement actions? Do they factor that in? Do they speed it up? Are they adding more immigration judges?
All of
Can you speak to that?
Yeah, sure. Yes, that is one of the things that, in terms of executive action, there you may or may not have heard. I mean, certainly the immigration judges, they're ALJs, and they are in a union, but they are being directed by their boss, which is the Attorney General of the United States, to speed up processing of, you know, their cases. There's probably a backlog of 600,000 to 700,000 cases in the Federal Executive Office of Immigration Review. And one of the reasons for this is because many of these individuals are probably eligible for some kind of immigration relief. They may have like a family visa case pending. They may have some other, you know, kind of administrative case that is processed by the immigration agency on the DHS side versus the DOJ side. The IJs, the immigration judges, are within DOJ, and DHS is responsible for processing and interpreting immigration law and processing those cases and those applications. And so many of those cases, you know, an individual may be eligible for some type of relief, but the issue is backlogs on the DHS side. You know, if it takes 4 years to have your visa application processed, one of the things that the IJs may do is just hold a case in abeyance. And there's a lot of pressure on the immigration judges. They've now got quotas in terms of how many cases they have to process within a year. And, you know, the majority of litigants in immigration courts are not represented. And I imagine all of you know what it's like to try to get evidence, relevant evidence, from parties that are not represented in front of you to actually provide a fair and thorough hearing and get all the evidence on the record and, provide some form of due process to the extent that that's possible in that context. And so they're under a lot of pressure to speed these cases through. And some of the specific executive actions from the DOJ, actually from Sessions, have been, like removing their authority, discretion to be able to continue cases, to terminate cases, et cetera. And so there have been some recent executive orders from Attorney General Sessions limiting the independence and autonomy of IJs to be able to manage their calendars. And so there are some efforts, on a larger front to try to remove the IJs from the authority of DOJ, or, to make it a non-political, less political entity. But, at this point, the IJs that I've known over the years, and I know the union has really been working to try to maintain as much judicial independence as possible. With respect to, yes, that backlog, they have a lot of quotas that about the numbers of cases that they have to do. They are trying to hire more to reduce that backlog, but with the increase in enforcement, the high level of increase in enforcement, a lot more of those cases are ending up in immigration court. And generally, everybody is entitled to be able to contest charges of deportability or removability unless they've been in the country for less than a year. Then there's an expedited process where they don't have access to, they're not entitled under the federal statute to a removal hearing. But if you've been here for a certain amount of time, under our Constitution, there is a right to due process as to whether or not, the charges against you that you're removable stand, and whether you're eligible for some type of relief. Yeah.
Is there a time reference when you're talking about likelihood to be a public charge? Because my question, like a young person, over time, the likelihood that they would remain a public charge is different than someone who's elderly, for example.
Correct. Well, so what the proposed rule does is it lays out a list of factors that the adjudicator needs to look at. And so it looks at age, family size, financial status, which includes the use of past benefits and whether they have income and resources, et cetera. It looks at family size. Yeah, it lays out a list of factors, and so age would be one of those things that is supposed to, weigh in the consideration. And there's some direction about some of the factors, not so much about age, but generally it does specify that somebody who's in school full time, that won't count against them. But perhaps somebody who's not likely to be able to support themselves and not work in the future. The proposed rule talks about that. And the test in the rule talks about a prospective examination for 5 years at least. And so the question will be, once the person's admitted, if they've used public benefits within 5 years of entry, whether or not later the administration will come and say, well, you became a public charge, so now you're deportable. And so, we haven't seen any guidance about that, the post-admission, what the administration is going to do post-admission yet, but we imagine that is next on the docket, for better or for worse.
In child support cases, one thing that's relevant is the ability of the parents to earn income if they're not employed. One barrier to earning income is not being able to legally work. In light of Evidence Rule 413 and the new governor's policy, how should I be thinking about questions that I can ask and questions that I can't ask to develop the record?
I think in terms of, we know lots of people work, whether they have lawful permission or not, and I think, in the same way that you would examine, their work history and what kind of wages folks make in those types of jobs. Yeah. Perhaps, seeking information about, job searches or their ability, how many, I don't know. I mean, that's a good question in terms of sorting that out. But I think that, there is a case out there, Salas versus High Tech Erectors, that talks about, trying to examine that. It's an older Supreme Court case, and in trying to figure out how, and that was a case involving damages relating to, somebody who was injured at work. How would you determine that person's ability to earn money, and how much those, I think I would follow that as guidance. I mean, ultimately, the rule does provide in civil cases the ability to do an in-camera review. I don't know what kind of process there is in your cases to examine that and try to figure out how to maintain the privacy or confidentiality. And perhaps that is an exercise that your office may be wanting to sort out in terms of how do we get that information in the record, and also, comply with the intent and purpose, which is to not allow evidence of immigration status to be used to discourage people from accessing, or causing either bias or to discourage them from accessing these services. And so, making explicit findings about why you're might be asking a particular question may be important for your record. But again, I think that that's a policy issue for your agency in terms of how you maintain the confidentiality and of that information, and not having it end up on your court if there's a review of your case and ending up in public record. So, sorry, I don't have a fixed answer for you on that one. Anything else?
I was curious, you talked about some folks responding to these changes by not seeking benefits. Mm-hmm. Based on anecdote and also on data, how are immigrant communities in general responding to these changes beyond that? What are they doing, or are they even aware of them? How aware are they, and how do they become aware?
Well, I will say that word of mouth is certainly a lot, and ethnic news media. I know that we are definitely hearing, at least from the service provider side, whether it be your public health folks or I've certainly heard from teachers around the country that people are even afraid to be coming to school, that after a highly visible enforcement action, that all of a sudden none of the kids are half the kids are not even in school. People are, and we are hearing from victim advocates certainly that is the case, that they're even just that they don't want to leave their house, and so there's a lot of organizing through churches and through immigrant community groups and others to help support folks around how to get access to just economic resources or food benefits or food resources, etc. But I'm hearing it across the board that people are just afraid to have any attention at all. So whether it be going to a government agency or going to school or going to the doctor, that people are just hunkering down and not. It's not universal, but certainly we're hearing that across sectors on whether folks are willing to come out. And in terms of the work that I'm doing at the national level, at least we're hearing from the membership organizations and all the different groups that these are what teachers are saying, these are what healthcare providers are saying, that all of a sudden folks from certain communities are just not they're not attending or reaching out or going to their medical appointments, etc. So we as a state are trying proactively to counter that, but there's only so much that we can do with respect to countering that. And the governor has made clear that state resources can't be used to assist in immigration enforcement, but we also have an obligation as, you know, as government to follow federal law. And so those are the places where, you know, sometimes there are exceptions to, you know, the state not providing information to ICE. Sometimes they do have to provide information to ICE. And of course, that's going to be the thing that shows up in the news, right? And so that's, you know, the governor cannot order all of, you know, all of its employees to intentionally thwart federal law. And so that's the challenges in that gray area, right, is where people hear about those exceptions and it stokes, you know, increased fear. And, you know, the technicality of, like, yes, they had a criminal case they were investigating and there was a warrant that was signed by a judge. I mean, that is not going to translate to the ground in terms of, you know, when that person is picked up at, I don't know, the ESD office or whatever, I don't know. but that, you know, that's the reality of how information is shared in immigrant communities. Yeah, any other questions?